Adjournment request, if any, from item number 1 to 7.
Wait, please, Your Lordship. I beg to mention item number 5 with the consent of the other side, Lordship. Kindly 3 weeks time may be granted to file an affidavit, Lordship.
Madam, it's a affidavit, no,
Lordship.
counter affidavit on behalf of 6, 7, and 11.
7 we have already filed, Lordship.
What
You want
about
to-
6 and 11?
Hmm.
Let the number comes, in pass and out.
Obliged.
From item number 8 to 15. From item number 16 to 23. From item number 24 to 35.
Item number 12. My senior speaker, Roy Chaudhary, is coming from those.
Item number 12.
I presume it's item number 33.
Sorry.
And that councillor had a word with me in the last evening, Miller. 33, I'm for the appellant. Possibly that would be the mention. Speaker or Chaudhary,
33 melody, I am, and I don't for the, yeah,
Which
melody.
one?
33 melody.
33.
Well, Madam Consul, which matter you have mentioned, madam?
No,
No mention. So,
33.
Yes, sir.
Yes.
33 for melody filing a counter melody. 2 weeks time may be required.
2 weeks. Is there an interim order?
there is, not bound by time.
Huh?
Not bound by time.
Acha, not
Not bound by
limited.
time.
May please, Your Lordship. Lordship, I had to mention item number 32, my lord.
Yeah.
With the other side consent, my lord, 2 weeks time may be granted, my lord. Personal difficulties.
Yeah.
May I please, Your Lordship? Lordship, I'd like to mention item number 35. May kindly be passed over for the day, any other day, Lordship. Taken concept with the other side.
Adjourn.
Obliged, Lordship.
May it please your lordship. When I pray for listing of a new writ appeal be filed today, possibly it might be infructuous by tomorrow. Difficult in the crux of the matter is that in it
Monday. Tomorrow. Tomorrow.
obliged lordship.
Lordship, I beg to mention item number 25, Your Lordship, with the consent of the other side, Your Lordship.
35.
25, Your Lordship.
25.
We need 2 weeks time to file our affidavit, Your Lordship.
Is the matter?
Lordship,
What's the matter?
regarding Rule 28, Lordship, of the Assam Education Provincial Service Rule 2018, Your Lordship.
Adjourn.
Obliged, Lordship.
Adjournment request from item number 36 to 53. Any other request? Daily list for orders, item 1.
May I please, Your Lordship? May I please, that matter may be passed over time being. My senior, he is stuck in traffic. He'll be here in some accommodation, Your Lord.
What about this,
Lordship, these instructions were sought for as to whether the arrears were paid.
yeah,
As per the instructions, it was paid on 29/11/2018. All the arrears.
29, 11,
2018.
In the last occasion, you just see this, order dated 26/6/2024.
Lordship.
This, has already written a letter to the manager, State Bank of, so-and-so behind working hospital so-and-so for dispersing the pension to the tune of rupees 1,12,500 so-and-so. In the, it is the case of the petitioner that the arrears of pension from November, from 1/1/2016 to November to the, has not been paid till date. That has been paid.
That has been paid on
Where is that?
29th of
What is the
November.
communication?
Lordship will find the remarks column in the right-hand side. The arrears, it was paid on by two transactions on 29/11. Your Lordship. In November 2018.
Fine, affidavit of this. Okay. Learned counsel appearing for the which
Respondent number 5 and 6.
respondent number 5 and 6 is submitted that the arrears of pension from 1/1/2016 to November 2018 has already been paid to the petitioner as per the PPO dated 29/8/2018 on 29/11. 20, which date you are mentioning?
29/11/2018.
29/11/2018. Learned counsel for respondent number 5 and 6 place some time to file an affidavit of this effect. Time paid for is granted list after 2 weeks.
Item 2 and 3.
Your Lordship, we will start with item with PIL 6.
This is the PL 6.
Your Lordship. PIL 6, which relates to a discrimination which came up by the state government, formulated by the state government in recruiting the trans persons.
Yes, we are having this PL 6.
Yes, yes.
Yeah,
Wait, please, your lordship, we have filed our affidavit today,
That is
Additional
pertaining to
affidavit.
PIL 2.
too, yeah,
So what happened to 6?
lordship. Not PIL 6. Yes,
so the issues are different or the issues are same?
Here, your issues, the main issues in this PIL 6 is your Lordship will find. The government, the police department, they came up with an advertisement. Your Lordship may just see the advertisement, which is at page 72.
Yes,
So here your Lordship will find in a bold letter, recruitment for 320 male and transgender, 314 female 6 post of sub-inspector AB, means arm branch, for newly created Assam Police Commando Battalion. So now when this advertisement came into place, their contention is not a single transgender applied. But what are the evolving principles you have given to the community for necessary application so that the trans persons can come and apply? That was not at all been inducted here in this advertisement.
what do you mean by that? Evolution, what do you mean by that?
Your Lordship will find that in the Nalsa judgment,
Yeah,
the Supreme Court has specifically said that the trans persons can either be termed as male, female, or as third gender. Here in this advertisement, what they did is they have collabed the trans with the male persons. Now, what are the various the conditions which has been given in this advertisement that are as same as what the male candidates was been asked for? So now can a trans person can compete with a male person? Suppose a trans person who has undergone a surgery from male to female or female to male. So is their biological compositions will get matched with the male persons? So this is one of the one of the very much discriminatory advertisement that we have in the Assam government. So after
Just
that's what the rules.
But in this PIL 6, kindly have a look at the order dated 16th of February 2024. 16th of February 24.
That's it. Yes, yes, I think it has been included, isn't it? I'll put it. 16.
But considering the matter, my lord, since it's a policy matter, my lord, ultimately the lordship has found that the concerned department has to be made a party, and accordingly they have been implemented. Now, my lord, they are required to file the affidavit because my lord, how it will be the evolving principles that will be my lord,
for that purpose now, as per your request, then different criteria has to be specified for the
Yes.
transgender persons.
Yes,
it is
And
a-
this-
it is
For
a
that
matter of
purpose, there may be requirement for amendment of the rules also.
yes.
yes,
But-
and your lordship will find that this advertisement came into place after Trans Act. And your lordship may also see just page 62.
Where is that Nalsa judgment?
Nalsa judgment we have not annexed here because
Please show us the Nalsa judgment. What are the requirement? What are the directions of the Supreme Court? Whether is there any specific
your
direction?
lordship,
to-
we don't have the judgment here, but I can provide the citation. It's 2014 5 SCC 438.
In this matter, this state has already filed reply.
No, my lord, in fact, my learned friend, Mr. Das, he appears for the respondent number 4. Here, my lord, the DGP, State of Assam, written by DGP has been made party, and a particular selection process has been, my lord, shown that that has not been followed. And, my lord, our instruction is
So
that
social justice and we have already,
Yes,
respondent number 4 is a party,
so whether any replies filed on behalf of the respondent?
Not
number four?
needed.
possibly, my lord, they have not filed.
Why?
All instructions are still awaited for PIL 6 of 2022. But today we have filed the additional affidavit for PIL 2 of 2022.
What affidavit you have filed now?
that affidavit is pertaining to PIL 2.
PIL two is in the.
It's a different issue.
That is, that central government, some guidelines.
No,
and
no, that was for establishment of the Office of Transgender Welfare Board.
That is.
That is
You
complete.
should file reply in this. What is your stand? As per this Nalsa judgment, what state government is required to do and what they have done till date.
I should kindly grant us 1 week time to file the.
File that reply.
Because your lordship, the main
understand.
problem which will again arise from this PIL will be, so as this advertisement has now been gone, candidates has been selected, they are now trained, they are now on the provisional duties. So the time period which we missed, the community person has missed, where they will go now? Someone who has
consider that.
exceeded the age limit.
We'll consider that.
In fact, my lord, our instruction was that in that process, there was no trans person, my lord, they applied. my lord.
That's why that is her grievance is, that is the grievance of the petitioner is that since there is no different criteria has been mentioned, how they can compete with the male counterparts?
No, nobody,
Nobody has
that is the
applied
policy
since.
decision.
That's
That is
why
the-
only the petitioner is saying that on account of this difficulty, since there is no different criteria for that, they have not applied, there is no
It's a,
question of.
it's a instance, my lord, they have shown by referring to that selection process.
Whatever it may be,
Lot-
you file reply, the Social Justice Empowerment Department should file reply. When once we have included it as a party, then.
Yes, my lord.
Okay. My daughter dated 16/2/2024. This has implemented Social
Grant us 2 weeks.
Justice and Empowerment Department Assam.
Lordship, 2 weeks time may be granted.
Just a minute, listen the order. Assam as party respondent number 4. Stop. Please notice that till date, no response is filed on behalf of the Social Justice and Empowerment Department Assam. Learned concept appearing for the respondent number 4 is directed to file an affidavit clarifying the stand of the state government on the issue raised in this PIL petition within a period of 2 weeks. This can fix the date after 2 weeks, fix on so and so. Yes,
Second it.
Obliged.
22-8.
22-8, no?
22.
Item 4.
May I please, Your Lordship? May I please, Your Lordship? And for the respondent number 3, Lordship, my senior is under bereavement, so I pay for take up this matter next week.
please speak loudly.
My senior is under bereavement, Lordship. I pay for proceed this matter next week, Lordship. And for the respondent number 3, Lordship.
Missing autonomous council.
Arjan,
Develop.
Item 5.
Sir, my lord, affidavit will be required by the principal secretary affidavit.
how much time?
3 weeks time, Lordship.
And counsel so and so is appearing for so and so, place some time to file. Counter or additional affidavit?
Affidavit in opposition, Lordship. Oh,
Affidavit
respondent
in
number 6.
opposition. This counsel and so.
Obliged.
Obliged.
Item 6.
Well, in other similar cases, my lord, the termination period was regularized. But in this case also, my lord, steps will be taken, my lord. I have received the instruction. There are 2 writ appeals, my lord. In the connected writ appeals, regulation order has already been
Yeah.
issued, my lord.
Also,
My lord, we'll fix it after 1 week, my lord. In the meantime,
Okay, Mr. Katniar has submitted that the process of regularization of the service period of the petitioner by the Secretary of Government of Assam Department of School Education is going on. And the same is likely to be completed within a period of 2 weeks. Just after 2 weeks.
One, Lordship, 1 week may be granted, Lordship. Graduation list is being prepared, Lordship. You will be suffer.
1 week now, then 2 weeks.
obliged.
Item 7.
Appellate lordship. There is delay of 101 days lordship. My lord, the other appeal lordship, challenging the same judgment has been admitted lordship. My lord, in our case lordship, there is a delay. We have we had no, my lord, knowledge about the, my lord.
Identical appeal has already been admitted.
Lordship.
Identical appeal has been admitted
Yes, lordship. My lord, this is the order lordship. My lord,
against this very same order.
same judgment lordship.
My lord, our objection we have filed, my lord.
Was filed.
Only our case is that, my lord, delay is of here, he has calculated 101 days, but there should be 140 days. Because, my lord, if a person does not apply a certificate within the limitation period prescribed, my lord, then that period he will not get to get the certificate copy. My lord, this is the judgment, my lord, that our objection may be recorded, my lord.
The matter comes upon for consideration of the IA.
There are
number so
31
and
and 34, my lord.
so, IA number so and so,
Yes.
with the prayer to condone the delay of
Yes.
101 days in filing the
Paragraph 31 and 34, my lord. 31.
Filing the present appeal. Full stop. The net concept for the
Respondent number 2.
applicant has stated that the delay has satisfactorily, the delay has been explained in the IA.
Paragraph 2, 3, and 4 was.
It is also submitted that in identical, the appeal against the impugned judgment, this court, while admitting the petition, is pleased to issue notices to the respondents. Stop. Learned concept for the
Respondent number 2, my lord.
respondent number 2 has vehemently opposed the
There are 7 of my
IA
affidavit.
and
my lord.
has submitted that the delay in filing the connected appeal has not been explained satisfactorily.
And 140 days delay.
Council has placed reliance on the decision of the Honorable Supreme Court rendered in V. Nagarajan versus SKS Ispat and Power Limited and others reported in 2022 to SCC 244. Stop. Having heard the learned counsel for the petitioner and after going through parties and after going through the contents of the application and also taking into consideration the fact that against the impugned judgment, one appeal as the appeal number, writ appeal number 324/2023 has already been admitted. We deem it appropriate to condone the delay of 101 days in filing the connected appeal. Hence, the IA is allowed. Delay of 101 days is condoned. Registry is directed to that, that is already registered. So registry is directed to register the connected appeal and list it for admission after 2 weeks.
In the meantime, my lord, he may serve one
Yes, sir. I'll
memo
serve,
of
Lord.
appeal, my lord.
You are not in talking terms with him.
My lord,
You are not in talking terms with him.
I am, my lord.
Ask him, he'll
Yes.
provide you.
Definitely, my lord. Obliged.
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 Item 8.
May I please your lordships? I am appearing on behalf of the petitioner in this case, my lord. Yeah, my lord, this case is pertaining to the fact that the petitioner is a bona fide purchaser of one flat, my lord. And he is
Who is
not,
appearing for the respondent number 4 and 5? Service complete on respondent
yes.
number 4 and 5.
yes, my lord, service has been completed, my lord.
What about 6?
6 was earlier completed, my lord.
Earlier completed.
Yes, my lord. All the services has been
As
completed.
per the office report, service of notice upon the respondent number 4, 5 and 6 has been, has already been affected. Service of notice upon the respondent 4, 5 has already been affected. Place this matter for admission after a week. Interim order,
Interim order.
continue till next date.
Highly obliged, your lordship.
Item 9 to 11.
Yeah, please, your lordship.
Yes.
In this case, Mr. Das, senior counsel, P.K. Das is appearing and he is out of station and I am not aware of this case. But still, he had instructed me that steps had been taken against the respondents.
Respondents, Affidavit filed on behalf
on-
of, in respect of respondent number has been received. Affidavit filed in respect of respondent number 125 has been received. When it concerned for the petitioner that submitted that steps for service of notice upon the respondent has already been taken. Stop. One eight 2020. One is C. One is C. No, yes, yes. I may. 414, 416. Verify whether one respondent to my damage has been served. Put up a note. One eight 2024. From the office note dated 1/8/2024, it is not clear whether the notice served, issued to the respondents in the respective IAs have been served or not. Office to place a proper note. And the office to make a proper note and place it before this court after 10 days.
Item 12.
We've taken steps, Lordship.
So as per the office report, steps have already been taken by the counsel for the petitioner for service of notice upon the newly implemented respondent number 2. Let notice be issued to. Number 2 is not amended. Is not amended.
You have not filed amended cost title.
We have not filed.
Notice will not go.
Still, you have not filed amended cost title. Though you have taken steps, but amended cost title is not.
Will file.
The
Within-
counsel, though steps. The steps have been taken for service of notice on the newly implemented respondent number 2, but the amended cost title has not been filed. When it concept to the petitioner placed for and granted a week's time to file amended cost title on filing of the same, let notice be issued to the respondent number 2, returnable 4 weeks thereafter.
I'm deeply aware.
Item 13.
Fresh,
13.
sorry, fresh matter,
Lordship, IA number 2312 has been filed.
fresh. Till date, notices have not been issued.
No,
Issue notice, returnable notice.
Item 14.
May I please lordship? That I is for condoning of delay minor only
Same
12 days. Sir. That's all.
Item 15.
Milord, it's regarding regularization of a part-time lecturer in University Law College. Milord, I have taken steps on respondent number 2, 4, and 5 2 times, Milord.
Now you want
Last
to
1 year,
delete
so
their name.
for
You
deleting the
want to
name,
delete them.
this I has been filed, Milord.
Okay.
And also to take up my interim prayer. Milord, it is the judgment of the Honorable Single Judge is not in tune with Uma Devi, Milord, that constitutional bench judgment.
So
So, Milord,
what interim player you are seeking?
Milord, for stay of that judgment, Milord. Otherwise, we'll have to consider the regularization.
Lord, I'm appearing for respondent 1, my lord. So far, my lord, respondent 2 is concerned, my lord, it is a necessary party, my lord.
Just formal parties, Milord, they have not taken part.
But
2, my lord. My
the
lord,
principal University Law College.
yes, my lord, because specific direction was given to him also, my lord, to consider the case of the, my lord, the present respondent number 1.
If
to regularize.
they want to delete the respondent number 2 from the array of the respondent and they on their own risk,
Milord,
what we can do?
most particularly, Milord, one contempt petition is pending, Milord. That is why, Milord,
What are
that
heavy
interim,
the matter comes, this IA is filed on behalf of the applicants with them there to delete the names of the respondent number 2, 4, and 5 from the writ appeal number 310/2023. Stop. Having gone through the contents of the application, the IA is allowed. The respondent number 2, 4, and 5 are ordered to be deleted from in the writ appeal number 310/2023 amended cause title at the risk of the applicants, amended cause title be filed within a period of
Milord, 1 week, Milord.
within a period of 1 week. List the writ appeal number. What is the writ appeal number? 310/2023 after 10 days.
Milord, sir. Most obliged.
Item 16.
This delay condemnation petition is received for the first time, my lord.
Lordship, I have telephonic instruction to appear on behalf of the sole respondent. I do not have the wakalat number as of now. It may be listed next week.
Delay condemnation 50 days.
Lordship, that's, I do not have the wakalat number. That's, I just have the telephonic instruction.
Issue notice, Mr. So-and-so accept notice on behalf of the sole respondent. Service is therefore complete. List this matter after a week, after 10 days.
Lordship. Same,
Item 17 is a similar matter.
similar man.
You are appearing for
Yes.
same order kar dena, 16 and 17.
Deeply obliged.
Do separate orders. But
Item 18.
There is delay in 48 days, my lord, filing the appeal.
Any private respondent?
Yes, yes, my lord. No, no, this is not this, my lord. This is idle man's matter, my lord.
Issue notice. Mrs. So-and-so is appearing on behalf of the
1 and 2.
1 and 2. That notice be issued to the other respondents, returnable. 3 weeks,
Obliged.
6 weeks, my lord, because there's idle.
6 weeks.
Item 19.
The
I have seeking delay, a confirmation of delay of 219 days, ma'am.
Huge delay.
It's poor fellow, my lord, he couldn't gather the, he couldn't be financially
Poor
strong.
fellow and engaged you. Strange. Notice returnable so and so.
Published.
For admission, item 20.
May I please, your lordship? Lordship, in this matter, my lord, I have appeared in the condonation application, your lordship. Now, my lord, my name has not been shown in the list, your lordship. And if this particular matter was from three custom appeal was from a common judgment, your lordship. So three appeals has been preferred by the department, my lord. So one has been listed today,
You are appearing in all
all the three matters, my lord. So my prayer is, my lord,
this matter, was the number of custom reference others?
custom appeal number, reference appeal number 2 of 24, my lord, one.
And
Another is 1 of 24 and another has not been,
one is today here, one is here.
one is today.
Another
One,
is,
two and another,
another is not numbered
No
yet.
number here.
numbered.
Not numbered yet. There are three appeals. There are.
List
there are-
along with the custom reference number 2/24. While reflecting the name of Mr. So and so, counsel for the respondent. After 2 weeks.
Achha.
Obliged.
Item 21.
May you please, lordship, maybe pass over the some time.
You are for?
I'm for the IOC, my lord. Basically, because of the cost, they've come up for the appeal. And rightly, the costs have been imposed rightly.
May it please the lordship. I'm sorry, my lord. Short of this. The issue is, my lord, that on that day, the IA was listed, my lord. And the IA was because previously we have challenged the tender by saying that, my lord, there are some illegalities. Respondent number 6 truck was on a direction from the court was seized by the CBI. And my lord, he applied for taking back the truck from the, my lord, CID. My lord, on that day, the IA was, my lord, listed. And on that day, because I was not present on that day, the case was repetition.
No one was present on last 2 occasions.
My lord, on the last occasion, on the day on it was dismissed, prior to that, I made a statement, my lord, that the case was, it was listed, but did not reach, my lord. I made a statement, my lord. That is at page. My lord, page 9, para B, facts of the case, para B. I'm only against that cost of 50,000. It's kind of a double jeopardy, my lord. Nothing else, my lord. On that day, my writ petition was dismissed and also the 50,000 cost has been imposed.
You agreed by the cost.
Cost, my lord, because my writ petition is dismissed.
That is already there.
But it was the
So
IA which was
now
listed.
how much cost do you propose?
My lord, because your lordship knows that I have been losing from all ends down. There was,
Maybe you are a transporter.
my lord, transporter, but I have lost in all the occasions. Neither no interim order was there.
So you propose how much cost you?
My lord, 5,000.
5,000. It's an insult to the petitioner. Isn't it?
Not an
The
insult, my lord.
Big contractor and only.
My lord, there is a saying, the wearer knows why the shoe pinches.
The people will say how the court is dealing with these big contractors. And it's a matter of shame for you also. 5,000 cost.
My lord.
They,
Then your lordship will.
engaged you.
No, my lord,
and,
sometimes,
5,000 cost.
my lord.
Okay. This, yes, what do you want to say, Mr.? This writ appeal is filed by the petitioner being agreed with the appellant being agreed with the order dated 15/3/2024, passed by the learned single judge in IA number 3843/2023. Stop. The learned single judge has dismissed the IA with the cost of rupees 50,000.
No, my lord, IA was allowed, my writ petition was dismissed.
IA was allowed.
IA was allowed, the truck was allowed to be.
The IA number so and so, so and so. Though the learned single judge has allowed the IA number 3483/2023, however, has dismissed the writ petition number.
Writ petition in, my lord, I'm just. Writ petition number would be, my lord, 6839 of 2022.
6839 of 2022 on the ground that despite calling the matter twice, none has appeared on behalf of the petitioner in the writ petition. Full stop. The court has also observed that on earlier two occasions also, no one has appeared on behalf of the petitioner in the above referred writ petition. Full stop. Learned counsel for the petitioner, appellant has submitted that the petitioner has no grievance in respect of the dismissal of the writ petition number so and so, but he is aggrieved by the cost of rupees 50,000 imposed by the learned single judge. It is submitted that it is submitted that the appellant appeared that the petitioner, the concept of the petitioner was very much present in the court when on last occasion the writ petition was listed, but on that day the matter could not be reached. Stop. It is also submitted that the cost of rupees 50,000 is too harsh and and therefore he prayed to take some he prayed for some leniency. Stop. Having heard the learned counsel for the parties and after going through the parties and after taking into consideration the fact that the appellant is not challenging the dismissal of the writ petition number so and so, we deem it appropriate to reduce the cost of rupees 50,000 to rupees 10,000. That's it.
My lord,
Rupees
my lord.
10,000.
I am always obliged to your lordship.
The appellant shall deposit the said cost within a period of 4 weeks with the Guwahati High Court Legal Services Committee. With these observations, this writ appeal is disposed of.
Item 22.
May it please your lordship. My lord, nowhere in the cabinet decision, any date was fixed. In fact, the cabinet memorandum, my lord, traces the entire history. And this approval has to be understood in the context of the cabinet approval. I think lordship would like to examine the matter, my lord.
But you create this relief for regularization or for absorption of your services since 1999 in the earlier writ petition.
Yes.
Now, in that petition has been dismissed with the specific observation that
There is
no
no
right
such
is-
right.
no such
But
right.
nevertheless,
And-
nevertheless, my lord, the matter was referred to the
is
government.
granted liberty, you may apply for that.
Now, eventually cabinet has taken a call.
The cabinet had taken a call to regularize your services from 2016.
No, no, where is it?
It is there.
No, my lord, kindly come to see.
Page 107.
My lord will kindly come to the cabinet memorandum first.
Yes.
Cabinet memorandum is at page number 199. If your lordship would kindly come to page 99, it starts
99.
page 99, my lord.
Not
199, yes. Now, if your lordship will kindly come to last sentence of para 1, Sri Soiful Alam has been working under the Panchayat and Rural Development Department till date since 13/3/99. This is all started. Then entire facts are narrated. Then, my lord, the Finance Department's views are at page number 101. Finance Department has no objection to absorption of Soiful Alam in the PNRD department if the said absorption is agreeable to both the lending and borrowing department, subject to there being no liability outstanding against him in the irrigation department, and subject to approval of the personnel department as it is an administrative matter. Then my lord will kindly come to the next page. Then views of the personnel department. Personnel department conveys it has no objection to the absorption of Sri Soiful Alam in PNRD department in a post equivalent rank in view of the precedents in this regard, and as incumbent has served for more than 17 years. PND department should, however, obtain the prior approval of the state cabinet for relaxation of the rule and his absorption. So this is, my lord, as far as then it is para 7. It is pertinent to mention that Soiful Alam is presently in an agriculture extension officer under the pay band so-and-so to so-and-so with grade pay of so-and-so and is working in the capacity of assistant project office agriculture in DRDA headquarters Naga in the grade of so-and-so. At present, there are vacancies having identical pay scale of posts held by Saiful Islam as stated below. Then eventually, my lord, at page 103, with the views and concurrence of the concerned referent departments, with their endorsement depicted above, Panchayat and Rural Development decided to permanently absorb the services of the Soiful Islam under deputation as assistant so-and-so with the approval of the Honorable Cabinet.
Yeah. Yes.
So, my lord, at page 103, eventually, the decision is since all the referral department has agreed, therefore, let us seek the approval of the cabinet. And the approval of the cabinet is at page 107. Now, when the accountant general wrote that letter, my lord, then all this subsequently, my lord, these interpretations have come up. The cabinet memorandum is very clear. I joined on 33/99.
Sir, the Learned Single Judge was right in.
No, Learned Single Judge never decided that issue.
Learned Single Judge was right in saying that though you were first absorbed in that department, but later on your repatriation to the department was upheld by the
No, my lord.
single judge.
My lord, the law is very clear
Yeah.
that unless there is a provision in the borrowing department, a person has otherwise no right. That I can follow. But here is a case, my lord, the cabinet, the highest body, has taken a call.
Well, in fact, he was repatriated in the year 2005. He had subsequently challenged his repatriation order. The learned single judge, my lord, had said that he has no vested right to be absorbed, and the liberties with the department to consider his absorption or not.
If any representation is filed.
His representation.
So therefore-
He has only a right to be considered, my lord. He never had a right to be absorbed. He never
So
had a
it has been
vested right.
considered now. Consideration is for
So
effective
his-
from which day?
That's why his date of entry would be with effect from 2016, when the cabinet gave its approval for
Yeah.
absorption,
Learned
not
concept of the-
1999.
Learned concept of the appellant.
My lord, if your lordship would kindly come to page 114.
Just a minute, sir.
Yes.
Learned concept of the appellant has argued that as per the cabinet decision dated. What is the date of the cabinet decision?
107,
Date.
27, 16. 27, 7, 16.
27th of July 2016, the appellant is liable to be absorbed in the services of the Panchayat department. Which department it is?
PNRD, Panchayat and Rural Development.
Panchayat and Rural Department from
399.
1999, when first he was sent on deputation. Full stop. It is submitted that the learned single judge has erred in observing that the appellant is only entitled for absorption of services in the Panchayat and Rural Development Department from the date when the cabinet has took decision and the respective department has passed the order. Full stop. Per contra, learned counsel appearing for the respondent number.
PNRD, Panchayat Department.
Panchayat and Rural Department has submitted that as a matter of fact, the deputation of the petitioner on the post of deputation of the petitioner with the PN department was cancelled way back in the year 2005, and the writ petition filed against the same has been dismissed by this court by learned single judge of this court by observing that
It was not dismissed, my lord, it was disposed of.
in fact was disposed of.
With a liberty to file.
Dismissal, yes, and it's a matter of dismiss while granting liberty to the, anyway, it is his
Submission.
while granting liberty to the appellant to file appropriate representation for his permanent absorption in the Panchayat Raj and Rural Department. Learned counsel has also submitted that in the said order passed by the learned single judge, it is clearly observed that the appellant has no vested right for absorption in the borrowing department. Would stop. Having heard the learned counsel for the parties, we are of the view that matter requires consideration and admit Mr. So-and-so except is appearing on behalf of the respondent number, respondent Panchayat Raj and Rural Department. Any other respondents are there?
What's
number 2,
Mr. So-and-so is appearing on behalf of the respondent number 2. All these
yes, Accountant General.
All official response.
3, 4 and 5. You also take the notice on behalf of the respondent number 3.
1 and 5, Mother.
You are appearing for 1 and 5.
1 and 5. 3 is finance.
Mr. So-and-so, the service is therefore complete. List for, this matter in due course.
Yep.
Item 23.
May it please your lordships. Well, this is pertaining to interpretation of a particular, my lord, notification of the government granting ex-gratia to persons who died in motor accident in a public place. Now, my lord, the petitioner's husband died in a road accident, leaving the appellant, my lord, and 3 minor children, and she applied for the ex-gratia of rupees 2 lakhs on the basis of that office memorandum. And when, my lord, no response was given, the writ petition was filed. The honorable single judge, my lord, rejected the writ petition on 2 grounds. Primarily, my lord, although there are 2 decisions of this honorable court by coordinate bench, single judge, my lord, deciding, directing such payment
Where is the notification? 31st of October?
My lord, 31st of October is at my lord is 40. By that, my lord, the earlier notification has been modified. It is 40. The Governor of Assam is pleased to exclude the cases of victims of motor accidents, except hit and run cases and the third party not traveling in vehicle persons hit by vehicles at public places from the purview of the ex-gratia policy as per OM dated 15 November 2014 in supersession of the said notification. That, my lord.
Now, the government has already.
Yes, my lord. My submission will be, my lord. This will be only prospective because, my lord.
Sir, that is not, can we apply for all other?
No, unless, my lord, it says that this is, my lord, if your lordship
We
kindly,
have already filed a motor accident claim.
my lord, motor accident claim has been filed, my lord. That is at the national stage. My lord. My lord, I have some submissions to make, my lord. The coordinate bench, two, my lord, judgments are there, granting that relief, and there are other cases also. And that has been,
Apart
my
from that, sir,
my
now this notification has already been amended. Now you can't say that since it was, it would made applicable prospectively and therefore she is entitled.
Yes, my lord, because my lord, the earlier, many persons have been given this benefit.
Whatever it may be, sir, but now if the government is not doing, then now today we can't pass any such order.
No, my lord, in fact, my instruction is that it was already made ready. Government did not, my lord, file any affidavit in opposition, no
It is
objection.
there, it is there, notification is there,
My lord.
it is in front of us.
No, it
How can
was,
we
it
ignore it?
was, my lord, processed and it was about to be, my lord, released because the other persons are getting, my lord, were getting after the judgment also, my lord. And my lord,
What happened in that MSCT case that is pending?
that is pending.
Then it's okay, sir, you
No, what the
can't have
question
that
will be, my
because
lord, question will be this aspect, my lord, whether,
hit and run case, certainly we understand, because if the vehicle is not known or not identified, then certainly the person can.
that is fine, my lord. My submission will be firstly, my lord, this is only prospective and my lord, the honorable single judge deciding on the basis of a judgment of the honorable Supreme Court,
Yes.
that has no application in this case, my lord. In that case, there was a, my lord, 309 rules under the, my lord, Haryana government, where, my lord, the government did not take any stand, my lord.
Having heard the non-conflict of the parties, we deem it appropriate to admit the petition, admit the appeal, you are appealing for?
I'm for the Revenue Department, Your Lordship.
Please,
And for respondent
name the
number one.
respondent number so and so.
One.
Only respondent number one. Yes, you are appealing. Respondent number?
226.
Mr. So and so is appearing on behalf of the respondent number one, and Mr. So and so is appearing on behalf of the respondent 226. Service is therefore complete. Listing due goals.
Oblige, my lord.
Children. Everyone issue notice, then this will come. Issue notice. Earlier matter of commission.
Item 24.
We filed an IA for expansion of the remark, which has been rejected by the learned single judge. My lord, only thing was, my lord, I am a successor in the office. My office didn't have the record of the earlier application. That's the only thing, my lord. Why should I retire with all these comments? Kindly see, my lord.
And how this comments are ultimately going to affect you? The effect of that.
Oh, my lord,
Next days,
my lord, why should I retire with such a, my lord, it's a very serious allegation, my lord.
It simply said.
No, Lordship will kindly permit me to place two paragraphs.
Seems,
Hmm.
it is not conclusion, it seems. The court has some doubt.
No, my lord. No, my lord, at least when I filed the IA, when the IA was rejected, now, my lord, things are different now.
That was simply observation. it
No, my lord.
seems.
After all, my lord, I am a conscientious person. Why should I retire with such an remark, my lord? And my lord, he was appointed also. Only dispute was when the application for compassionate appointment was made. And my lord, taking advantage of this, a 340 application has been filed.
Clarify it, that this is only a tentative opinion and carries no stigma.
And my lord, based on this, a proceeding under section 340 read with 191 to 195 has been filed.
That will clarify, then you deal with that.
Yes, yes.
This,
Clarify, go ahead.
yes. Who is up?
This is within the court and the petitioner, Manoj. I have nothing to say.
And what about this?
There's a private stay out there, Manoj.
You are
I'm the official respondent of the Forest Department.
then this who is respondent number Beena Devi?
But the private respondent, Manoj, who has filed a
She was
criminal
the lead
case.
petitioner in the
Lead
proceedings, my lord.
And she now filed a application
Yes.
of perjury.
Yes,
Then we have to issue notice.
issue notice.
Issue notice to the respondent number,
One minute.
respondent number 1. Mr. So and so is accepting notice on behalf of the respondent number 2, 3. The
3, 4, 5.
some- Who is the respondent number 2 then?
Two could say, then I did. Some mistake has crept in, Manoj. It should be 1, 2, 3, 4. One is there.
I think, my lord, there is, yes, there is
Typography
no
mistake.
two. Actually,
There's no 2.
3 should become
Two.
2, 4 should become, yes.
You do this correction in the court itself.
Go ahead, huh?
Respondent number 2, 3 and 4. Full stop. Let notice be issued to the respondent number 1, returnable on nineteenth of August.
Miller.
Returnable on 19th of August. Dusty AD. Registered AD and Dusty.
My lord, can we be permitted to serve notice upon the counsel who represented?
Again, the counsel will say, I am not representing and all of this.
We'll see.
Registered AD, you get the notice.
Yes.
All right.
We'll ask him if he agrees.
Item 26.
Actually, this petition is filed against the order passed by the learned Cat Guwahati bench, where the
Just a minute.
Selection. Deletion. You are appearing.
Chief Senior Advocate Mr. A.K. Behra is appearing to Hartfield.
Okay, acha, is BC?
Yes, Lord.
Yes.
Lordship. Against this order passed by the learned Cat Guwahati bench, where the Honorable Cat has found that the reasoning has not been provided by the selection committee while evaluating the ACRs of the officer concerned and for selecting him for the post of IAS. And Honorable Cat has also overlooked the fact that for selection of officers from state civil service to state police service to Indian police service IPS, separate set of guidelines are formed by the UPSC, which has been followed. And the guidelines which is issued by the Department of Personnel and Training for within cadre promotions are not applicable in this case. In this case, what happened based on the upgraded ACRs of the officer concerned, he was promoted from JAG 2 to JAG 1 by the UPSC, but it's a separate committee which based on the guidelines for internal promotions, they have considered it. But Honorable CAT has found that by when one committee has already promoted based on the same ACR, the selection committee has not provided any reason, and when one committee has already considered, the other committee has not considered him for promotion. But the fact remains that it's a lateral promotion from state service to all India service. So there is a separate guideline which is followed by UPSC.
What is the direction? Consider him again. And if it is not meeting those
He was already
whatever the
considered.
criteria fixed in the guidelines, again, say,
Lordship, he was already considered in the review selection committee.
review selection committee, the court has said that in that review selection committee, the upgraded ACRs were not taken into consideration. And particularly when another committee of the UPSC, on the basis of the very same upgraded ACRs, has granted him promotion from JAG 1 to JAG 2, then again consider it. And if you, these parameters are not, he is not meeting those parameters or guidelines, whatever you are having for that, again reject his candidature.
But the problem is the selection committee on 2 occasions has already considered his upgraded
On
ACR.
the first occasion, upgraded ACRs were not
No.
there.
Yes,
2 occasions, second occasion, you have taken into consideration.
right.
And on the basis of those upgraded ACRs, JAG 1 to JAG, JAG 1 to JAG, or JAG 2 to JAG 1, you granted them him promotion. And thereafter,
That is why
on the very same ACRs in 2017, he was promoted to IPS.
No, Lordship, because the criteria is totally different. From JAG 1, JAG 2 to JAG 1 is by the Departmental Promotion Committee. And from state service to Indian Police Service is by selection committee. The guidelines is totally different. And the considerations and benchmarks are totally different.
So, Mr. Todi, how are you agree with this direction? The tribunal, learned tribunal has not laid down any parameters binding you to take a decision in a particular manner. The direction is only to consider.
To consider, but
Consider, that's all.
Learned Tribunal has observed that we have not given any reasoning. So the selection committee is not bound to give any reasoning unless it differs from the previous committee. Since the previous
So
committee.
if that is your only grievance, we'll clarify it. You are at liberty to consider his case and take a decision as per norms that you think are applicable. Please do it. That's all.
Only observation, only the tribunal that we have not provided any reason and we are supposed to provide a reason. So that on that direction only
Without influence, without being influenced by any other observation. Just consider his case as per the norms which according to the UPSC would be
Yes,
applicable in this
that has
case?
already been done. It's a repeated exercise we have to do as per the direction. That's the whole thing.
That do it. Now 4 months now, 4 months are here. Do it. And if you don't find no impact, again reject it, candidature.
Because if the-
Ultimately, only the question is either to this promote him to IPS from 2015 or 2017. 2017 he has already been promoted.
True, right.
Consider it again. What's wrong?
May I be permitted to take instructions on this matter, Lordship? At two, at two, Lordship?
At two. At two.
So Mr. Todi, please appreciate one thing. If this is admitted, then there is a possibility that this court may tie you down by setting parameters. That is one of the possible outcomes. In that case, you cannot move here and there. You have to stick to the. So think about what.
At two. At two.
At two, Lordship. Much obliged.
Item 27.
In this case, the writ petition was dismissed on the ground that the disputed questions of fact are there, and thereby writ petition matter. Now, issue which was there before the learned judge was that fellow, whether the hospitals which provide the healthcare services and the medicines, etc., which are used or supplied to the patients, whether that will fall within the purview of the healthcare services and clinical services or not. Now, this issue, there is no facts involved in it. There is no, it is admitted by the respondents also that a hospital is there. They are not disputing that the medicines are supplied to the patients. So far as the medicines which are sold to outside customers, the GST is paid. Now, second issue which was there, that whether the registration which was there of this hospital petitioner at the relevant time was not for the clinical establishment. Now, that is also not disputed at all. The medicines which are supplied at the MRP, that is also not disputed. There is no question, not a single issue was there where the disputed questions are there. Now, the question, first question, whether it is exempted or not, unless and until that is decided, the second and third question will not come at all.
The landed single judge is essentially non-suited you on the ground that you have an alternate remedy, and therefore under Article 226, this court
the question that
want to exercise its discretion. That's the only thing.
Absolutely correct, madam. But the question landed single judge had that there were disputed questions of fact. Now,
no disputed questions.
Well, Ashwin said, see, he said that all the disputed questions which are determined. At page 412 million in the second volume. And the lordship at the time of hearing, in the affidavit of opposition, no objection was taken. At the time of hearing, the alternate remedy issue was not raised at all.
So in fact, the Honorable Supreme Court in recent decision has specifically held that when there is a complete mechanism of challenging the orders passed by the authority concerned and everything, then court should be slow in interfering in those matters.
No, in the recent decision in the Godrej Sarali Milord, the division bench Supreme Court Milord, has held Milord, you'll also may see that when the questions of law are there, then the petition should not be dismissed. I'm just giving. Lordship, kindly page 408.
Para 7, I think so. You are.
I'm referring to para. Hmm?
4, 4, 5.
4 or 5. Just above 5 million, it pays 108. 408 million. I'm sorry, 408.
408.
Well, after skipping 8 or 10 lines, million, in the long line of decisions, have you also got it, million? In a long line of decisions, this court has made it clear that the ability of alternate remedy does not operate as an absolute bar to the maintenance of the petition, and that the rule which requires a party to pursue alternate remedy provided by statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementary, it needs to be stated that interpretability and maintainability of petition are distinct concepts. To find the distinction between the two ought not to be lost sight of. The objection as to maintainability goes to the root of the matter, and it's such objection were found to be of substance, the court would be rendered the incapable of even receiving the list of the adjudication. On the other hand, the question of interpretability is entirely within the realm of discretion of the High Court. Writ remedy being discretionary, a writ petition, despite being maintainable, may not be entertained by the High Court on the very many regions, and relief may be refused to the petitioner despite setting out a legal points. If granted to the claimant, and relief would not be for the public interest. Hence, dismissal of a petition by the High Court on the ground that the petitioner has not availed that remedy, without however examining whether an exceptional case has been made out for the court's interpretability, would not be proper. Well, in the various advanced rulings in different states, my lord.
Gives that देना जरा GST
GST, no? May I place some provisions, my lord, if you also permit me, my lord?
just
My lord. Room rent is exempted, food is exempted, ambulance service is exempted, medicine is not exempted, my lord. Medicine not required for the patient.
Pets pay we are not examining.
And in fact, my lord, at the time of hearing, this objection was not raised at all in the affidavit, it was not raised.
The court can also raise,
No, no,
even
I
though
can- I-
the
I'm-
court can, at the first hearing, the court can raise this
My lord,
objection.
it was not raised. The
And we are
objection.
raising every day.
My lord, the question that, my lord, I had no opportunity also to make submissions because it was only in the written submission after hearing, he made a submission in the written submission. So, my lord, your lordship, I'm submitting only, my lord. The question of law purely is that, my lord, whether medicine which is supplied to the patients, indoor patients, my lord, whether that will fall in the
Agreed,
healthcare
sir.
service or not.
Agreed, though, that there is no disputed questions of fact are involved. And only purely question of law is involved. Then also, when there is a complete mechanism provided under the statute, why should this court should,
The court has thoroughly, it has been said.
then thereafter the three judges bench has
My lord,
said,
the
three
apex court,
judges bench has said something other.
the apex court, whenever they want to dismiss it, they say that.
That's the only thing, sir. That luxury is with the apex court, not
Then they
with
say,
us.
my lord, you go to alternative remedy. But when a case is made out, my lord, the apex court said that yes.
It has, however, been clarified that the High Court will not entertain a petition or article consider if an effective alternate remedy is available to the aggrieved person or the statute under which the action complained of has taken itself contains a mechanism for redressal of
My lord, that-
grievances.
my lord, when they say that it is not absolutely bad, apex court is saying, and on the other hand, apex court says, my lord, that there is no
Then,
central.
then you can predict a dilemma.
My lord, the
What
dilemma is that, my lord, the 226, my lord, petition interdictability. My lord, it is
And
absolutely.
often it is seen, sir, whenever the court entertains.
My lord, it depends on
certainly
the, my lord, it has to be taken, it depends on the every case to case.
Dr. Saraf, there is a problem here. The question before this court is not whether it should be sent to the alternative remedy or not. The question is the approach of the learned single judge illegal?
My lord.
Is the approach of the learned single judge illegal? That's the question here. We have to hold that this was an illegal approach to set aside the order. Can it be done in the court of?
If your lordship permit me, your lordship, just see, my lord, then a single says, just says, these are all disputed questions of fact. Your lordship, just, if your lordship permit me, my lord. At the judgment.
Page number?
It starts, my lord, that I will take your lordship directly to the page 427.
Para?
Page 427, para 23.
Yes.
There is also no challenge to the bias of the legislature in the present case in volume 2, my lord. In this petition, therefore, on this count, also this court is not inclined to exercise discretion arbitrary to its constitution here. Another aspect of the matter is the controversy raised is that the petitioner that they are providers of healthcare services and therefore it is exempted from payment of GST, though by mistake of law they had already paid GST. On the other hand, it is the case of the authority that the petitioners has sold the medicine consumable to the patients at market price, and thus the burden of the tax is transferred to such consumers. The other aspect of controversy is that coming to the authority, that relevant point of time, the pharmacy of the petitioners hospital was regarded as GNRC pharmacy and food and sewerage division for supplying goods, medicine, so and so, but not on the head of healthcare services, and therefore they are not entitled to such benefits. On the other hand, it is the case of the petitioner that they have subsequently amended the registration, therefore they are entitled to the benefits of these disputes. These are disputed question of facts, and such disputed question of fact cannot be resolved efficiently in the appellate authority under section so and so. Right. I'm sorry. Right, give me a minute. Assuming that an item like rice may be exempted, somebody collects the tax on the rice illegally. Now that will not make rice taxable. That amount which has been collected may be forfeited.
Dr. Saraf, we don't dispute that. On merits, you may have a very good case, but certainly when this mechanism, all mechanism is there, why should we entertain and what's,
But you
as my lord has pointed out, what's the illegality? in
But that is
judgment?
illegality that the learning single said these are all factual disputes which can be, there are no factual disputes.
It
And
is
lordship,
another, another, this remark by the learned single judge, but ultimately the learned single judge is influenced by this fact, when the effective or efficacious remedy is available, this court.
day in, day out, your lordship, whenever your lordship
that's all.
finds that there is a merit in the petition, your lordship is entertaining the petition in spite of the alternate remedy. There are all the throughout minority and admitted.
We are entertaining, sir.
It is not a case that the petition are never entertained without alternate remedy. So it is not such a case that the petition cannot be entertained. And when the petition was entertained, if no opposition was filed, matter was heard. All.
That is. Nothing else. This is what.
My submission there, that this matter needs at least consideration by the lordship, and if in case, either your lordship may hear the main matter itself, or the matter may be remanded back to the single judge for consideration of on the merits.
Yes, Mr. Kat.
Lordship is seeing the judgment of the single judge. Recently, Lordship has pointed out the full bench of the Honorable Supreme Court.
Which one?
A recent judgment in PHR Invest Indication Society. Full bench of the Honorable Supreme Court.
No full bench.
Full bench, Lordship.
Which judgment you are referring to? No.
Paragraph 15.
The same judge. Let's see, you already have the copy of that.
This is the recently Lordship Supreme Court decided that where an efficacious remedy is available, a petition should not be impacted.
Close for orders.
Much. But 27, 28, 29, and
In item 26, in 27, in fact, the issue was raised was that the refund application was filed belatedly delayed. And the question which was raised before any single judge was that whether the delay, the time period is directory or mandatory. Now that has also been disposed of by the same judgment without considering that aspect of the matter.
Item numbers?
28.
27, 28, 29, and 30. 4 minutes.
Yes.
But these issues sending. I'm obliged.
Thank you. Yes.
Yes. Item 31.
The petitioners were given promotion. The promotions were given in abeyance, kept in abeyance. Subsequently, they were set aside eventually. That's selective compliance, you know.
Who is appearing for the respondent?
The forest department is appearing in the matter.
Who is the counsel?
D. Gogoi is there. I had a word with him. Now, difficulty we have put now, you know, the. Although my lord, so pleased to stay the issuance of the notices, but they are refraining for giving the promotions. On the other hand, prior to this, when we had filed the contempt applications, due to pendency of the division bench matter, that again is standstill, madam.
But in this matter, my senior Mr. Goswami will appear, my lord, additional AG, because he has found out something. We are complying with another order of this honorable court, my lords.
That's what our query was.
Yes, my lords.
Why we have not complied the earlier order and jumped to pass the consequential order which the learned single judge has granted liberty, that you can pass it after providing notice, after giving notice to them.
My lords.
So straightway, without complying with that order, whereby the this order was set aside.
My lords.
How can you do that?
I will kindly come to page number 48.
This is the only, yeah, 48.
48, my lord, paragraph 8. And then my lord come to, that is a finding that they are not entitled.
Para number 9.
9, my lord.
Consequently, the
Consequently,
improved
my lord.
order 2722 stand set aside and the order detailed stand restored. What is this order 29/6/2021? They were their promotion order.
29/6, my lords.
You have to revise that stand restored.
Promoted, my lords, they were promoted.
Promoted and
Yes,
later on that promotion was cancelled on 2/7/2022.
My lords.
That order has been set aside with a specific direction to restore their promotion.
My lords.
Now,
Then
without
para 10, my lord,
restoring
we are
that promotion.
We are complying with para 10.
Para 10, what para 10 says?
Para 10 says, my lord, they are not eligible, my lord. They should be given the my lord, individual notice. That we are giving, my lord.
And after giving the opportunity of being heard in the matter.
Yes, my lord. We have given them only.
But before that, you have not restored their promotion.
My lords.
Do it.
Perhaps he will appear, my lord.
Who will appear?
Mr. Additional AG PN Goswami, my lord. He will appear, my lord.
We just
advised,
want this and we clarified on the earlier hearing.
My lord.
Also can do it and then come.
Let me, who is the person required to comply with this order?
My lord, this is a PCCF, my lord, administration, admin.
Let him be present to VC on the next date.
Yes, in fact, they had sought a legal opinion
What
for
way
us.
he has understood the order?
In fact, they had sought a legal opinion for us, from us.
We are not.
Your legal opinion you may give or may not give, or you may give it adverse.
My lord,
We are
listed
not
on next
bound
week,
by
my
that, your legal opinion.
My lord will list it on next week, my lord, because they have not, the appellate have not assailed the order of that early order what Lordship had pointed out. They have challenged the next order of.
Sir, is there any ambiguity in
No,
what
no.
facts we have submitted?
Sir.
We understood the matter.
Yes,
Sir.
my lord.
When their promotion was cancelled, they approached this court And the court has said, okay, they are not having the requisite qualification, therefore this order can't be interfered with. But our question is only this. You can complete that exercise, or you could have completed that exercise only after restoring their promotion, then only you could have done. Otherwise, you can't.
What is the list is of next week? We have tried to advise them, my lord, they are writing letters. I will advise them again, my lord, next week.
I can personally.
Genuine difficulty, my lord, if we pass on those benefits now, my lords, again, my lord,
So
my
there
lord,
is no
till the
question
gap,
of
my lord, that intervening period, my lord, many persons will come, my lord.
come, then they'll come. This was the court's order. You can't do that. You can't ignore the court's order.
Is
You have
that-
not challenged that order, first order.
My lord.
You have not challenged that first
No,
order.
no.
Then it has attained the finality, you have to comply with it, and then only you have to do.
You have partially complied with it. You can't even challenge that order now.
No, we're not challenging, my lord.
Okay. Then the concept for the forest department. Raise some time to complete his inspections. List the matter on 14th, no, 13th. 13th of August. 13th of August, if by that date, the order passed by this court in writ petition number
794, I mean, not.
794, no.
794.
No,
No, no.
no, 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 sir. It
Five
would be, Malad,
5299, my lord.
5299/2022. Dated
2022.
22, dated 1/2/2024 is not complied with. The principal conservator of forest.
My lord, PCCF, my lord, PCCF administration, my lord. Administration and PCCF legal, my lord, 2 persons are there, my lord. One is PCCF legal, one is PCCF admin.
Present through VC before this court.
Sure. My lord.
Obliged.
Always.
Based on
Supplementary list for orders item
The interim
54.
order may continue, but the protection.
interim order is need to continue till next week.
Oh. Well, this matter, the affidavit has been sent for vetting. Let's have a look at the instructions. In fact, my lord, in principle, we are supporting this.
What principle you are supporting it?
In principle, my lord, that because my lord, they are. Let's even go through once.
Where you are residing?
My lord,
Where you are residing? When you reached home day before yesterday, at what time?
9:30, my lord.
And still
I
you
had
are
the last
happy.
letter in this
And
court, my
still
lord.
you are happy.
No, no, my lord, we are supporting them, the petitioner.
What do you mean by supporting them?
And
It's
then
not
in
a
fact,
question of
the
supporting
prayer may be
supporting or opposing it.
No, my prayer may be considered too.
Today the newspapers have reported like anything.
Well, I'll kindly go through, my lord. So the forest department as
What was the reason? What was the reason for this mess? What was the reason for this mess?
I represent
How it happened?
Well, I represent the forest department. So as such, we don't have any role, but
Sir, we don't want this forest or finance or anything else. We want a response from the state, that's all.
Yes.
We are not here, this is your own business,
My
this
lord.
department or that department, we are not concerned with that. Please don't come with these, please, every time. This is the finance department, this is the revenue
saying
department.
that, my lord,
State is
my lord,
state.
I am saying, just we have gone through it. We have prepared something, my lord. We just need a week's time.
What preparation you just show?
My lord, the Guwahati has 16
First
number
of all-
reserve forest, my lord.
First of all, how this has happened? Why it was not happened earlier or 2-3 days, years before or 5 years before? What is the now change? What change is there now?
Lord, can I make one submission?
It's not a matter that
Overnight,
the
yes.
rains,
Overnight.
come for the first time here.
Yes, madam.
Well, I'll respectfully submit, not by of anything else. Let the chief secretary of the state appear before this honorable court and explain what is the comprehensive plan under which is they would like to undertake to at least save the Guwahatians from all this menace every time.
That's right.
I think, my lord, let chief secretary appear, then he can speak on behalf of the government of Assam.
That is the only way.
Yes.
Is the only way.
And what we will do, my lord, on behalf of the bar, we are also filing, tomorrow we are filing that application seeking intervention, we've already ready.
No, we allow you, don't file any application, we'll allow you. This is a public interest petition.
Yes,
You
yes.
don't need to go into all these formalities.
Mr.
Lord,
Sai-
enough is enough. Now they should come up with some comprehensive plan. Let the citizens
And,
know, but they're, but not blaming that water from Meghalaya is coming, that is not the
No, but
answer.
sir, that may be a situation. So
Yes.
at least even
So
though
we
if
have
it
to-
is coming from Meghalaya or it is
You have
coming
to-
from Arunachal, you have to
Yes.
tackle that problem.
Yes.
This is not a.
Is Mr. Saikia, Advocate General Assam in the court? Is he present?
Call advocate.
Can you please
Call it. Yes.
call him?
He's
Yes,
here.
yes. In fact, that
বস্তুটো ঠেলি দিছে আপোনাৰ PWD ৰেভিনিউ আমি এনে লিখিছো যে এইটো নকৰিবা
petition of you fine.
Acha, Mr. Saikia,
Lordship.
Situation was very bad. Let's understand it. Now, it's not a question of blaming X, Y, Z here and there. It's not an adversarial issue also. But the fact remains that things are taking terrible shape. Maybe the government is looking into it. We are sure something is being done. But a few questions now, a time has come when it should unfold, even before this forum. So what we are thinking is, we want to request, first of all, your personal.
Yes, that's why
attention
when I
here.
heard, I immediately.
Yes.
Now I have gone through it.
Let us go in a systematic manner. Let the government do whatever is required. We don't want to interfere. But the only problem is these things are not yielding any permanent solution. Things are happening since last 15 years, 12 years. People are trying to do these, divert water here, build culvert there. But the fact of the matter is that every year, almost every year, there is 1 or 2 days which is creating havoc. And in an important city like Guwahati, which has got a very substantial population, it has got a very significant presence in the country's map. This cannot continue. Therefore, a few questions to begin with. If you could kindly throw light on that on the next day. First of all, Why did it happen? Last Sunday with a little bit of 1.5 hours rain. What is the reason why this kind of a?
Lordship, I have dealt with these kind of issues in the earlier round of PILs. We always came up before this honorable court. A lot of steps has been taken, and therefore, if Lordship remembers, Lordship has said that 15 years, for last 15 years. Prior to that, Guwahati had about 31 wards which were affected by this kind of thing. And when there is a water logging, it continued for 2, 3 days, 4 days. Because of continuous efforts, irrespective of who is running the government, whether it is Congress or BJP, I'm not on that. The problem which created by this kind of rainfall as well as that artificial flood which is commonly used, the time duration has substantially reduced. Now, taking the example of Tarun Nagar and Anil Nagar, major thrust of the government was on that area because that was the lowest area in the city of Guwahati. If you look at the topography of Guwahati, Lordship, it is surrounded by hills all along. Every year in the month of March, February, and April, all the drains were cleared. This year also, substantial amount of money. My learned friend also represents some of the contractors. So every year that amount of money is spent to clear the drainage before the monsoon comes. The problem with Guwahati is that Guwahati is surrounded by hills and it is like a ball. So when there is a major rainfall, along with the water, the soft soil of the red soil of the hills come and again blocks the drain. That problem during the monsoon we cannot do. That is one measure. But ultimately from 31 wards, we are facing this problem. Day before yesterday, situation is totally different. We have reduced it to 4 to 5 wards where rainwater is actually creating problem. In all other places, Lordship, GS Road or the Jew Road, those areas, Lordship, earlier, it has to take about 8 hours to 2 days to clear the water. Now, within 1 hour, 2 hours, the water is cleared. The problem is that the television channels, they take up the photographs of a particular moment. It has been repeatedly shown. That is the problem that people are getting that as if the water, that is one area. The time duration from 2 days, it has been reduced to few hours, maybe 2 hours, 3 hours. It remains, then it clears. Day before yesterday, situation is totally different, Lordship. That is an exceptional thing. That happened on 5th of October, 2 years ago also, on a particular day. Just like in Mumbai, 26 September, if you all Lordship. That is one classic example, but it cannot happen regularly. So now, this petition, I have just gone through it, Lordship. The major things which is being said that there are soils coming from the hills and National Highway 37, 10th mile, 9th mile. These hills do not belong to Assam. They belong to Meghalaya. If Lordship is pleased to come to paragraph 9.
We are not.
No, Lordship, we have to understand the problem and we have to find out the solution.
Pleadings in the petition. The pleadings may be or may not be.
No,
there.
that is why.
We are taking it, you take it as it is that we are taking it so moto cognizance, looking into the fact
I
that
fully agree. That
day
is what
before
it is.
yesterday's situation, when the people were not able to reach up to midnight to their houses, that's the.
That is one of the rarest of rare situations.
And the problem, whatever it may be, now what measures you are proposed to take to tackle
What
this
measures
situation?
and
This is what
measures
the question is.
The measures are being taken for last 15 years. Time to time, new measures are being taken.
But those measures are not sufficient for that reason.
Yes, Lordship. So it has to continue because we have to admit one thing. The geographical location and terrain of Guwahati. No other city is having this kind of terrain. When the city, it is like a bowl. গোটেই মাটি কাটি সমান কৰি দিছে না এতিয়া পৰহি মাটিত কালি মিনিছে ৰঙা মাটিতে
And you like with this.
So we give a proper response, Lordship. And number two, Lordship, the main problem was earlier the Bhorolu River. We have sufficient number of water pumps all along the Bhorolu River now. So therefore, yesterday's problem, the day before, it did not started from Bhorolu. New areas are being affected. The Khanapara area, that never had.
It's a dynamic issue. We understand.
New problems are being cropping up.
It's a dynamic issue, but at the end of the day, a solution has to be found.
Solution.
Because explanation is not the point. Point is finding. the
What we
solution.
could also appreciate that we have also dug out a tunnel from the Zoo Road area to Brahmaputra from the other side. That solved a lot of problem. The Gitanagar, this time nobody is talking about Gitanagar. Why? That was the major area where the water logging was there. All these waters are being diverted.
Who is the head of disaster management?
The
Secretary.
deputy commissioner.
Deputy
Deputy
commissioner.
commissioner.
No, district level. No, the state level.
State level.
Additional chief secretary revenue.
Lordship, that Dohua department is also there. So I'll come with the proper affidavit, Lordship. Central government.
Is there any department, disaster management department?
Revenue and disaster management, that is the revenue and disaster
Revenue and disaster management.
So the principal secretary there. He is the additional chief secretary.
My lord, let us not take it as an adversarial. Whatever had happened, happened. Now government should come up with a comprehensive plan. My lord, I have one submission on that. Now we understand government will undertake in a right earnest. Let us also take the views of some experts in the field, my lord. Every time political executive may not be the right person to take all decisions. Let this plan which government proposes to take be approved by experts in the field. Because we are not experts, we can only point out, as Lordship has said, we must find out a solution. I know, yes, my learned friend is absolutely correct when he describes the contour of the Guwahati city. Yes, it's like a ball. Therefore, maybe some measures which ought to have taken, we have not taken. Therefore, let the experts be drawn into the thing, my lord.
Let them.
That's my only request.
Let them come with their
Yes.
proposal.
If the
And in that, if there is, we find that some lack is there, then certainly. we can
Certainly, my lord. Only thing is, my lord, Lordship will kindly continue to monitor it so that, my lord, some shape is taken.
And this is one classic PIL, Lordship, where I am finding the first time that they are raising the most critical trouble which the city is facing. That is the encroachment on the hills. That is one area because the soil becomes very soft when there is construction. There should be actually plantations.
Correct. Mr. Chaudhary, apart from whatever has transpired so
We'll
far,
also come up with some suggestions, my lord.
there is one particular area where we would request you to look into and come
Yes,
up with suggestions. You see, this whole thing, there could be lapses here and there.
We are not on
That's
that.
another thing.
Yes.
But somehow one feels that even these citizens, the
Yes, yes.
residents of Guwahati city also need to be sensitized on a few things.
Yes, yes. Why not?
Because the
Absolutely,
citizens also
absolutely.
have a duty. Their cooperation is also required. Garbage disposal,
And littering everywhere, my lord. Yes, yes.
These are also issues which have eluded the attention, I would think.
Rather, all these things aggravate the situation. my
Yes.
lord.
So why don't you examine that aspect of the matter? The government will require cooperation of the people
Of course,
also.
of course.
Without that, nothing will succeed. Merely spending money, coming up
Yes.
with plans, unless there is cooperation from the public, residents, it will be difficult to implement any scheme effectively. So this time we want to focus on that
Yes.
area also.
If necessary, my lord,
I
we'll
fully
impress
agree.
upon
I'm
the
not
civil
taking it as
society
an
also.
adversarial litigation. We want monitoring of this honorable board.
Yes.
Question of taking this adversarial litigation, in fact, we all are on the same page, that these problems should be solved permanently for whatever they are. That's the only thing. Okay. This petition, this PIL petition is filed, raising a concern about the problem of water logging in the Guwahati city. To stop this court has granted time to the Council for the Revenue and Disaster Management to file the management department to file a response and the response to the petition. And pursuant to that, the response has also been filed. It is though the date was not fixed in this PIO, but on a mention made by Mr. K. N. Chaudhary, Senior Counsel and President of the Guwahati Bar Association, day before yesterday, yesterday.
Yes.
This matter was listed, this matter is directed to be placed before this today. Full stop. Mr. Chaudhary has invited our attention towards the flood situation. The Guwahati city has witnessed on which was the date?
Fifth.
On fifth of October, fifth of August 2024, which stopped. The newspapers of the public newspapers have also extensively reported the situation and the trauma faced by the citizen of the Guwahati city. Full stop. We are of the view that now time has come to dealt with the problem of waterlogging, public flooding in the Guwahati city, and the state is required to take steps in steps for resolving this problem permanently. Full stop. We request, we have requested Advocate General Mr. D. Sekia to assist the court and also extend a request to Mr. K. N. Chaudhary, Senior Counsel, to assist this court as amicus. Full stop. Taking into consideration the fact situation, we deem it appropriate to grant some time to Mr. Sekia to place on record the
Comprehensive plan.
a comprehensive plan to be prepared by the Revenue and the Disaster Management.
Lordship may indicate that what is the existing plan, because plan is already there. And also the future plan, both.
To place the plan which is in existence and the future plan
To deal with this.
to deal with the menace of waterlogging and flooding in the Guwahati city within a period of by the next date of hearing. Full stop. The copy of the said by way of filing an affidavit through the Revenue and Revenue and Disaster Management Department, by filing an affidavit of the Revenue and Disaster Management Department, Government of Assam, through its Principal Secretary. Full stop. Copy of the said affidavit we also supplied to Mr. Chaudhary and the counsel for the petitioner, Mr. Who is appearing?
I'm SU on that.
Mr. So and so in advance. Full stop. List this matter on when
Maximum 10 days may be given, Lordship.
10 days. Okay. 19th of August,
Lordship.
19th of August.
Lordship, instead of Revenue Department, Lordship, the Department of Dohua.
Department of
I'll just give the full name. Housing and Urban Development Department, DO.
So this revenue.
Actually,
disaster-
everything,
Revenue and disaster management is not
the
supposed.
plans and everything are done by Dohua. Department of Housing and Urban Development.
In place of that.
DOH.
Earlier that affidavit is filed on behalf of the.
I'll give the
Revenue
full
and
name.
Disaster management, but another bylaws can that is. Now,
Please.
first we have noted that reply is filed on behalf of the revenue, that is there. But now this something, whatever.
No, because they are conducting all the activities. Highly offensive.
For hearing, item 24.
Make decision appeal against the judgment of the Honorable Single Judge, my lord, passed in WBC number 4460/2010, setting aside the order of the Assam Board of Revenue, my lord, where Assam Board of Revenue cancelled the order of the settlement officer granting mutation to the respondent. Here, my lord, in this case, little facts are like this, my lord. One, Swami Paramananda Saraswati purchased a plot of land on liquidation. And at the time of when the land was purchased on liquidation, my lord, all are free from encumbrances, my lord. But there were tenants, some tenants were sitting on the land, my lord. Then this Swami Paramananda, he leased out the land to one person, my lord, that is on Moon Tea Company in 1974 for 30 years. Thereafter, my lord, what happened? A suit was filed by one Ex-gratia and suit was title suit number 24/77 against the manager of the Moon Tea Estate. They have not made not made Swami Paramananda Saraswati as party in the suit, my lord. And in that case, my lord, the injunction was granted, and against that there was an appeal. Ultimately, the matter was compromised. Then a tripartite agreement was entered into by the parties, my lord, without taking consent of Swami Paramananda, who is the owner of the land, my lord. Then in 1973, government initiated land sealing case, my lord, against the Swami. And Swami submitted return of excess land, including 73.20 acres of land in DAG number 78 out of 90.23 area shown as free land. Then, my lord, Ex-gratia sold the land to one Abhijit Singh and others who are the respondents now. Now, my lord, here there is no any sale deed, but deed of relinquishment, my lord. So ultimately, Ex-gratia by relinquishment deed number 2408/99 dated 1/10/91 confirmed selling of 90 acres of land. That was not the sale deed, my lord, that is a relinquishment deed. Now, thereafter, these petitioners, my lord, they filed the application for mutation, and mutation was granted by the settlement officer. Against that, there is an appeal before the Assam Board of Revenue, my lord. Assam Board of Revenue observed like this, my lord. Your lordship may be pleased to see that which was enclosed, which was narrated in the judgment itself, my lord. Your lordship may be pleased to see at page 189 of the memo, my lord, para 31. It was the observation of the learned board, my lord. Having discussed the above, the judgment and order dated 8/4/2010 may now be adverted to, relevant portion of which is extracted hereunder. The respondents have primarily based their claim on the orders of the Honorable Munshi Karimganj dated so and so in title suit number 24/77. Their case is that once the title suit has been settled by the Honorable Munshi,
The learned settlement officer had no option but to record the names of pre-cassia and thereafter by the purchaser. The fact of the case as they emerge create an awkward picture. The ownership of the tea estate in question originally is of Swami Paramananda Saraswati. Thereafter, the trust formed by him, the present appellant, is the owner. The compromise deed signed by somebody other than the owner is a case wherein the learned court had been misled. Decree holder thereafter had not approached for mutation of his name ever. In between, his name has been struck off as an occupancy tenant and a ceding case has been finalized. The compromise decree also only states that there is no objection to the inclusion of the name of pre-cassia of the land record. It does not state the ownership stands transferred in the name would be recorded in place of the owner. Even in 1991, pre-cassia has not approached for mutation of his name. In the others who had approached with free registered relinquishment deeds signed by pre-cassia for himself and others, how the learned settlement officer accepted a relinquishment deed as a valid document of transfer of title by purchase is not understood. What the relinquishment deed, whatever rights pre-cassia and others had over the land got extinguished, and so far as he is concerned, the land become government land. The settlement officer does not have the authority to settle land as per the policy decision and other provision. Even if the decree of the civil court is examined, pre-cassia and others only obtain order of having their names mutated in the land record. The compromise deed, which form a part of the decree, does not state that the name of Srimad Swami Paramananda Swami would be deleted. However, right of pre-cassia have been lost by his not approaching the revenue authority for mutation ever, and also by signing relinquishment deed. It is on record that a land ceiling case was initiated against Durganagar Tea Estate, in which 73.20 acres of land out of 90.20 acres of Dag number 28 had been declared to be in excess and therefore was required to be made sarkari. The remaining 17 acres of land was found to be free from occupancy tenant and was left with the appellant. In view of the above, the appeal is allowed. The impugn order of the settlement officer dated so and so passed in miscase number so and so, order dated so and so passed in miscase, order dated miscase are all set aside. Any further mutation allowed on the basis of acceptance of the ownership of pre-cassia over 90.20 acres of land of Dag number 28 are also set aside. Action in respect of Dag number 28 was taken in accordance with the order passed, land ceiling case number so and so. In terms of the said land ceiling case, 73.20 acres of Dag number 28 to be made sarkari, and action be taken by the learned Deputy Commissioner Karimganj in respect of this land as per the guidelines laid down for ceiling surplus and land. Remaining 17 acres of land of the in the said Dag number shall remain to be mutated in the name of the appellant as was allowed to be retained in the said ceiling case. Before parting with this case, some more directions need to be given. This seems to be a case of fraud wherein an attempt has been made to take away ceiling surplus land and the land of the appellant. The revenue authorities also seem to be involved in it. A land ceiling case was initiated in 1973. A tenant obtained a decree from a civil court in 1979 based on a compromise deed, which is not signed by the owner. The decree holder is not in the picture thereafter. In 1991, some persons approached the settlement officer for mutation of their names based on 3 relinquishment deeds of the decree holder. The settlement officer first makes the name of the decree holder without an application from him on the basis of decree, which is 12 years old, and then
mutates the name of others by right of purchase and possession of ordained number so and so. A relinquishment deed has been accepted by the learned settlement officer to have created a right of purchase. The secretary of the board will refer this case to the learned principal secretary to the government of Assam in the revenue department for having a criminal case against the matter with the CID. Now, para 32, my lord. On going through the impugned judgment and order direction, it is seen that the Board of Revenue had gone beyond the decree of the civil court dated so and so, passed in title suit number 24/77 and virtually nullified the order of the civil court. This is absolutely, my lord, wrong finding of the honorable single judge, my lord. Now, during the pendency of this writ application, my lord, my learned friend has stated that a civil suit was filed and civil suit was dismissed, my lord. Because after it appears, my lord, the civil suit was filed after the disposal of this case, that is before the Assam Board of Revenue. The Assam Board of Revenue case was filed in 2008. Then Assam Board of Revenue passed this judgment on 8/4/2010. Then there against a review application was filed by them. That review application was at that time pending. Thereafter, the suit was filed on 3/31/2010 after the disposal of the Assam Board of Revenue. Then the suit was dismissed on 29/3/2018. Now, the Honorable Single Judge has passed the judgment. 180, no? At page 180, my lord, Annex 3, that was passed on 12/11/2018. Now, during the pendency of this writ application and hearing, my lord, my learned friend has stated that the civil court has already been disposed of. But my learned friend has not stated that against the judgment an appeal was filed and the judgment of the trial court was stayed. And it is still now, the case is stayed. They are in the court, appellate court, my lord. Now, this learned single judge, my lord, passed the judgment treating that the trust is not a religious trust, but it covered by the Indian Trust Act. That is absolutely not correct, my lord, because this in 1980, my lord, that Srimad Paramananda, Swami Paramananda Saraswati died. Now, in 1980, my lord, Swami Paramananda Saraswati died, and thereafter a trust was formed, and the lands, all lands were given to the trust, my lord. And trust is contesting all these things, my lord. Now, the learned single judge, my lord, observed that
please let us know what is where is that decree of the civil court?
Civil court is not between this, my lord, owner and others.
Whatever, where is
That was, my lord, title suit 24/77. That was with actually land was leased out to some tea company, my lord.
Page. Here, you have placed that decree record.
Decree is not annexed, my lord. It was observed in all the courts, my lord.
We would like to go through that decree. Because the learned single judge has passed the order that Assam Board of Revenue.
Actually, they have not annexed along with the writ petition, my lord.
Please place it on record, sir, without going into the decree. What rights have been decided by the civil court, and learned single judge has said that Assam Board of Revenue cannot disturb those, whatever the findings of the civil court. Where is that decree? Let us see. Is there any direction or decree in favor of the petitioners or not? Or the writ petitioners or not? Without the, seeing that, how can we adjudicate it?
My lord, now here, the locus of the trust is also, because this.
Sir, you first of all, please place on the decree before us.
Yes.
Where is that civil decree?
But the.
Judgment of the civil judge, West Bengal.
In title suit number 2277. Where is that?
Actually, this present
30th of
applicant was
April-
not a party.
30th of April 1979 in title suit number so and so. Where is that?
Have to check it out. But now the question is this, my lord, whether the trust has the locus, my lord.
We'll go to the question, another question first of all. Please, try to, हमको तो समझ में आएगा जैसे आएगा ना सर. तो वो उसके लिए थोड़ा सा आप
That
हमको.
is why, my lord, civil suit, civil appeal is also pending, my lord.
Whatever it may be, just show us. लिखिए. But in concept of the petitioner, appellant is directed to place on record the decree of the civil court dated
29/8/2008.
petitioner mention করছে তো আপনার আবার তারা আসেনি কি নাই না
That is by the. That is by the Alipur district.
क्या लिखा है? Dated 30th of April 1979, passed in title suit number 24 slash 1977, passed by the Munsif Karimganj,
My lord,
Assam.
it is here,
List after 2 weeks.
my lord, page 68, my lord, the order is there.
Which order?
That's municip order.
Translated copy is there, my lord, 71 page.
71.
Page number 71, my lord. The plaintiff and the defendants humbly submits that in respect of the aforesaid suit, both the contesting parties entered into a settlement as mentioned below. As per mutual settlement, the suit will be decreed without cost in favor of the plaintiffs. The declaring the
Sir, a 71 page is something different, sir. That is 29/2008 order is a. We want this 79 decree.
That is at page 68, my lord. That is a part of settlement, my lord, at page 70. 68 is order. 71 is the settlement.
I think so 85 of 2010. Let's see what.
at page 71, some observations are there, my
There
lord.
is another title suit 85 of 2010. The learned single judges observed that this judgment has not been brought on record by either party.
Yes,
Please
that,
see page 20, para 29.
yes.
But it is in this particular judgment of the Munsif that some observations and declarations have been made.
Yes.
Is that a part of the record?
That was produced later on, my lord, but that now 193 is there. It's I think, page 193, no? Page 193.
29/8/2008, where is that?
29th March 2018.
29th August.
Against the judgment, my lord, appeal was preferred, title appeal 21/2018 at page 2221.
Mr. Kalita, please read para 29 of the single judge's order.
Yes, my lord. Against that, the appeal was preferred.
Where is that judgment?
I have annexed, my lord, stay order, my lord. 221 page.
So can you make a small convenience compilance of all these? Three civil court judgments are there. One Alipur, West Bengal, and Munsif Karimganj 2. Can you just give us those judgment
Yes,
in a compilations? We'll have to go through it because the single judge's observations are based on the declaration.
Actually, Alipur court, my lord, declared that the trust is formed, my lord. Because under the, this is under the religious trust act, my lord, not under the Indian trust act. It is under section 3.
How much time will be required? 2 weeks or 4 weeks?
Whatever is fallen from a lordship, in the line we can dispose the matter.
Yes, what do you want to say?
Lordship.
Yes. Yes, Mr. Counsel. Mr. Behra.
My lords.
Yeah. We are disposing of this petition while since the tribunal has simply issued a direction.
Yes, my lords.
We are disposing of this petition
Yes.
with the since the tribunal has simply given a direction for reconsideration of the or to conduct a review DPC while
Yes,
considering the upgraded ACRs of particular years.
Yes, my lords.
The UPSC is free to take a call as per their whatever procedure or guidelines or the which they have mentioned that they are going to follow.
Yes, but that is the, in fact, they have, before the tribunal also, they had said the same thing. And the tribunal considered this and they have given this direction, madams, which I think, let's say,
Fine, fine.
please, madam.
This petition is filed by the appellant. Filed by the petitioner, being agreed with the order dated 22/4/2024 passed by the Central Administrative Tribunal Guwahati bench herein after to be referred as tribunal in original application number 0286/2021 filed on behalf of the appellant. Tribunal while setting aside the order of the MHA dated 24/9/2020, thereby the respondent was not found fit for promoting as IPS for the year 2015. Has directed the selection committee of the UPSC to hold a review DPC and access the upgraded ACRs of the respondent for the year 2005-06, 2002-03, and 2001-02 with the further direction if the applicant found, applicant would be found fit otherwise, he shall be granted the consequential benefit. It is also observed that such exercise should be completed within a period of 4 months from the date of receipt of copy of the or this order. The tribunal has taken into consideration that the committee of the UPS, selection committee of the UPSC has not taken it, while taking into consideration the upgraded ACR of the respondent for the aforementioned years, has not stated any reason for any reason before non-suiting him for promotion in the IPS cadre for the year 2015. Full stop. Learned counsel for the petitioner has submitted that as a matter of fact, the UPSC, the selection committee of the UPC is not required to give any reasons for reasons by declaring an incumbent not fit for promotion to the IPS cadre. It is also submitted that the UPSC it is also submitted that by virtue of the provisions contained in All India Service Act 1951 and the Indian Police Services appointment by promotion in appointment in promotion, this is in bracket regulations 1955. UPSC makes selection of the state police officers for appointment by promotion to the Indian Police Service based on the proposal and records sent by the concerned state government / Ministry of Home Affairs. It is contended that UPSC has a comprehensive guidelines / procedures for preparation of a list of suitable officers by selection committee for promotion to the Indian Police Service and is not obliged to take into consideration is not obliged to take into consideration only the ACRs of the incumbent. Full stop. It is contended that the quality of the officers and the other relevant aspects are to be taken into consideration while considering a case for promotion in the IPS cadre. And it counsel has submitted that the CAT as the tribunal has ignored all these aspects of the and has added in directing the selection committee of the UPSC to hold a review DPC in respect of the respondent. Stop. Having heard the learned counsel respondent, per contra, learned counsel appearing for the respondent has supported the judgment passed by the tribunal. Having heard the learned counsel for the parties and after going through the judgment passed by the tribunal as well as the material available on record, we are of the view that the learned tribunal has simply directed the selection committee of the UPSC to hold a review DPC and assess the upgraded ACRs of the respondent for the year 2005, 6, 2002, 03, 2001, 02, and thereafter to the two full stop. The UPSC and the tribunal has not issued any direction either to promote the petitioner in the IPS cadre for the year 2015, nor has given any observation regarding the upgraded ACRs of the respondent. Full stop. True it is that the selection committee of the UPC is bound by the guidelines framed for the purpose of assessment of the officers for promotion in the IPS cadre, and even while holding the review DPC, the UPSC can follow the said procedure stop. We make it clear that while holding the review DPC, the selection committee of the UPC is not supposed to influence by any of the observations made by the tribunal in the impugned judgment. So in such circumstances, we don't find any case for interference. However, looking to the fact that the period of 4 months granted by the tribunal is about to complete, we extend the said period for further 2 months to carry out the directions given by the tribunal in the impugned order. With these observations, this writ petition is disposed of.
Much obliged. For hearing, item 36 and 37.
Mr. Kayal, Mr. Kayal, you are not appearing in these matters.
36, 36, 37.
Who is appearing for the other side?
Dr. Saraf is there.
Then
Item 38.
May it please lordship. My lord, the only issue is, my lord, whether the appellant was right in shifting the liability for paying the service tax to the service, my lord, giver as a service receiver could have shifted the liability to the service provider. Now, Learned Single Judge has held, in view of the decision of the Supreme Court, my lord, in the Rashtriya Ispat case, that they can shift if there is a contract to that effect. But by misinterpreting the terms of the contract, my lord, the Learned
who
Single
is
Judge,
from the other side?
but on other side did not appear, but amicus were appointed, and then he or she also, there is an order to that effect. The nobody is appearing. You know.
The other one. Where is he? Today he has come.
No, my lord, there is an order. She has retired. I think she's not no longer there.
She's retired?
I mean, there is an order because the client did not contract her after the order passed by this court, my lord. So.
The appellant has made personal service of the sole duly acknowledged.
If she is not appearing, this one will be that content, right? If she is not, if she is completely appearing as amicus.
Or lordship may like to appoint any other lord.
See, we'll wait for one more time.
Lordship.
Because the notice was personally served upon her,
Lordship.
upon the respondent. Therefore, this happened. So none appeared on behalf of the sole respondent this after 2 weeks.
Item 39 to 53.
Lordship, the matter may be taken after some time, Lordship. AG sir is on late, Lordship, in other division.
Yeah. 6 weeks. Check. 6 weeks.
But since I